I'm Will Lehman, and the federal monitor tasked with overseeing the UAW election has rejected my protest. The monitor's response to my protest is entitled to no credit or deference whatsoever, in light of outrageous conflicts of interest on the part of the monitor's office, namely the law firms of Crowell and Moring and Jenner and Block. These firms are partisans of the auto corporations with which they have close ties, and their interests are adverse to those of rank-and-file union members working for those corporations like me. Jenner and Block has long-standing ties to General Motors, and the firm's financial and legal relationship with GM goes back many years. It is worth recalling that in 1937, during the sit-down strike against GM in Flint, Michigan, the judge who issued an injunction against the strikers, Edward S. Black, was removed from the case after it was revealed that he owned 3,000 shares in GM. Here, the conflict of interest is even worse. My internal union protest against rampant voter suppression in the election was denied by a law firm which consists of lawyers that represent GM. In 2014, the New York Times wrote that, quote, Jenner and Block has done high-profile securities work for GM, end quote, as well as, quote, product liability cases, end quote. GM spokesman Greg Martin was quoted as saying that the attorneys have, quote, reputations for adhering to the highest standards, end quote. The Times continued, quote, both firms have done extensive work for GM. The carmaker has used Jenner for more than a decade, and its work includes advising GM on its post-bankruptcy initial public stock offering and negotiating a $5 billion line of credit for the company in 2012. The firm's website says it has represented GM in product liability cases involving vehicle incompatibility/aggressivity, crashworthiness, airbags, rollover/roof crush, and seatbelts, end quote. The relationship between GM and Jenner and Block is so close that in 2006 it hired the head of corporate practice at Jenner and Block, Robert Osborne, as its general counsel. According to the Wall Street Journal, while working for Jenner and Block, Osborne helped GM spin off auto corporations, leading to massive job losses and wage cuts. In a June 8, 2006 article headlined, quote, General Motors taps Jenner and Block lawyer as new general counsel, end quote. The journal wrote that Osborne, quote, represented GM in the disposition of Hughes Electronics, the spin-offs of Electronic Data System, Hughes Defense, and Delphi, and the sale of National Car Rental. He also has represented GM in public offerings of stock and debt securities, end quote. In other words, the firm responsible for monitoring the election is actually responsible for the decades-long attack on the rights and the living standards of the rank-and-file auto workers and retirees. This is a direct conflict of interest. Such a firm clearly has an interest in helping GM suppress our wages, lower labor costs, and attack our rights in the upcoming contract as well. Most notoriously, Jenner and Block helped conduct the investigation that absolved GM's executives of criminal responsibility after the company covered up ignition defaults that led to the deaths of many people, including several children. Anton Valukas, then chair of Jenner and Block, testified before Congress in defense of GM. One of the Jenner and Block attorneys tasked with helping oversee the UAW election, Reed Shar, was a leading figure in the GM ignition scandal. According to Shar's Jenner and Block profile, he, quote, served as one of the team leaders conducting an investigation and producing an internal report to the board of directors for GM regarding recalls stemming from faulty ignition switches. The firm's team coordinated GM's response to several federal agencies and Congress. Reed represented GM in a related investigation by the U.S. Attorney's Office for the Southern District of New York, culminating in the resolution of the matter through a deferred prosecution agreement, end quote. The head of the Center for Auto Safety, Clarence Ditlow, issued a statement at the time attacking the investigation and Jenner and Block's role as GM's lobbyist. Quote, GM killed over 100 people by knowingly putting a defective ignition switch into over 1 million vehicles, yet no one from GM went to jail or was even charged with criminal homicide. This shows a weakness in the law, not a weakness in the facts. GM killed innocent consumers. GM has paid millions of dollars to its lobbyists to keep criminal penalties out of the Vehicle Safety Act since 1966. Today, thanks to its lobbyists, GM officials walk off scot-free while its customers are 6 feet under, end quote. Jenner and Block's conduct of the election and their contemptuous attitude to the rights of rank-and-file workers like me is in alignment with the interests of their client, General Motors, particularly as the expiration date of the current contract approaches for 48,000 UAW members at GM this year. Crowell and Moring has equally deep ties to auto corporations negotiating contracts impacting hundreds of thousands of rank-and-file members in 2023. Its clients include Caterpillar, General Motors, Mazda, Bosch, Dana, BMW, Daimler, Bridgestone, and other companies. Like Jenner and Block, there is a revolving door between the top attorneys at the firm and GM. In 2019, Crowell and Moring appointed Lawrence J. Lines to its Orange County, California office. Lines was, quote, most recently litigation counsel for General Motors, end quote, where he served for 35 years, according to a Crowell and Moring press release dated June 18, 2019. The firm's website has a section titled, quote, Labor Management Relations and Labor Disputes, end quote, which explains that the firm, quote, regularly represents employers in collective bargaining and negotiations and grievance arbitration matters, and advises clients in developing and implementing strategies to prevent, or if necessary, minimize the business impact of strikes, lockouts, or other work stoppages. We have successfully handled hundreds of union election proceedings involving employers across the country, end quote. Crowell and Moring's website states they, quote, successfully represented Caterpillar before the U.S. Department of Commerce, end quote, and that the firm, quote, has extensive experience in negotiating with and litigating against the most sophisticated labor unions in the country, including the International Brotherhood of Teamsters, American Postal Workers Union, Service Employees International Union, International Longshoremen's Union, the Auto Workers, the Machinists, the Steel Workers, International Brotherhood of Electrical Workers, United Food and Commercial Workers, and numerous other labor organizations, end quote. In 2013, it represented General Motors in a $3 billion lawsuit. The firm holds regular training events for how to oppose strikes, including one held in October 2022 as the UAW election's first round was taking place. It was called, quote, a conversation about responses to the surge in union organizing, end quote, which advertised giving corporate attendees, quote, an opportunity to share experiences and exchange best practices on responses to the current wave of union organizing, including an increased willingness to engage in economic strikes, end quote. The firm's search engine also yields an article discussing how the firm helps companies identify the, quote, earliest stages of potential union organization campaigns, end quote, and helps them, quote, through the actual campaigns, elections, and potential challenges, end quote. It appears the firm attempted to scrub this article from its website, but failed to remove it from the search results. According to LexisNexis, Crowell and Moring currently represents GM in a number of pending or recent cases across the country, including Vita v. General Motors, In-Ray GMC Air Conditioning, Marketing and Sales, Tucker v. General Motors, and Estate of Pilgrim v. General Motors. Earlier this month, attorneys from the firm appeared before David Lawson, the same judge in the Eastern District of Michigan that heard my lawsuit in November 2022, to represent General Motors. These company lawyers had no business denying my protest. Not only do these conflicts of interest violate the election rules themselves, which strictly prohibit the employers from interfering with internal union business, it taints the monitor's response to my protest as well as the entire election. The law firms overseeing the election had an improper motive to deny my protest and rubber stamp the entrenched leadership's suppression of the vote so as to ensure the victory of candidates likely to reach favorable agreements with the clients of these law firms, namely the auto companies. Meanwhile, if the monitor's office had agreed with my protest and agreed to rerun the election with meaningful notice to the membership, that would have created more favorable conditions for the interests of the rank and file to be expressed in the election, which would have been bad for their clients. There is the old adage of the fox guarding the hen house. Here the hens are also being required to pay the foxes hundreds of dollars an hour for legal services. This is a scenario that belongs in Alice in Wonderland or Kafka. Millions of dollars of UAW workers' dues money have been paid to date to these law firms for their services in overruling the objections of rank-and-file workers like me to the violation of our democratic rights. These corporate law firms acted throughout the election first and foremost as advocates for their corporate clients, not in the interests of the democratic integrity of an internal union election. They hardly even hide it. It shines through every sentence of their response to my protest, which drips with contempt for the indifference of rights of rank-and-file members like me to participate in a meaningful democratic election. Thank you.